Today, we will again discuss the process of moving an existing business from one state to a new state and why statutory mergers are usually the wrong way to accomplish that goal. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the great states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at the university level, and I hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Some attorneys and CPAs incorrectly recommend using a statutory merger to move an out-of-state LLC or corporation to a new state. This is usually a critical error. Mergers are blunt instruments originally designed for acquisitions and consolidations, not state-to-state relocations. Mergers are legally complex, tax risky, and administratively burdensome. Worse, they often fail to achieve the very objective that they are intended to accomplish, preserving the continuity of an existing business while moving it to a new state. If you want to keep your existing federal employer identification number, customer relationships, contracts, credit history, and corporate identity intact, redomestication is the far superior solution in many cases. A merger is not only unnecessary, it is dangerous in many instances. One of the most damaging consequences of using a merger to move your business to a new state is the possible loss of your federal employer identification number, or EIN. In a merger, the IRS may treat the surviving entity as a separate legal entity unless very narrow and strict requirements are satisfied. If your entity in the new state is the surviving entity, the EIN associated with your original company may be deactivated. That means you may need to apply for a fresh EIN, reset your business with the IRS, and reestablish payroll tax, 1099 excise tax, and income tax accounts. Any mistakes or assumptions in this process can result in penalties, sometimes significant penalties, IRS communication problems, and long-term administrative burdens. Mergers are not always and automatically tax-free, although many attorneys would lead you to believe that that is the case. It is simply not. If your business owns appreciated assets, has liabilities exceeding basis, or is structured as a subchapter S corporation or as a partnership, merging the entity into a new corporation, LLC, or partnership in the new state may inadvertently result in a taxable exchange under Internal Revenue Codes sections 351, 368, or 721. This is especially risky when there are multiple owners, historical losses, or intangible assets like goodwill. States may treat the merger as a sale or liquidation, resulting in capital gains, franchise tax recapture, or excise tax assessments. Redomestication, as contrasted with the statutory merger process, is preferable insofar as it avoids these risks completely by preserving the existing entity. No new entity, no asset transfers, and no deemed exchanges. And you keep your federal employer identification number. Statutory mergers are procedurally demanding and frankly quite complex. If anybody tells you they are simple, they are either misleading you or they don't know what they're talking about. Mergers require board resolutions, shareholder or member votes, customized plan of merger documents, and precise statutory filings in multiple jurisdictions. Most secretaries or departments of state require certified copies, wet signature, and or notarized documents. And if any of this is done incorrectly or in the wrong order, the filings may be rejected, the merger may fail, and your business may be left in a very undesirable state of limbo. Even under ideal conditions, it can take 8 to 12 weeks or longer to complete a merger between two states, and much longer in cases of large businesses. Redomestication, by contrast, is usually faster, simpler, less expensive, and more predictable, with a clear start to finish workflow and timeline that preserves the legal existence of the company from start to finish. A merger does not, quote unquote, move your business. It creates a new business. In most cases, the new surviving entity must first be formed, then designated as the surviving entity. This new entity is legally distinct from the prior business, even if it carries over the name. That means new bank accounts, new contracts, and new operating agreements, shareholder agreements, bylaws, and so forth. The credit history of the former entity usually does not transfer. Your vendor and customer relationships may need to be renegotiated. Licensing agencies may require you to reapply. Insurance policies will likely terminate and will need to be rewritten. And if you miss a single step in the onerous merging of interests, stock certificates, or membership units, you may face future litigation from co-owners or their successors. Most contracts contain anti-assignment or change of control clauses. A statutory merger, especially one involving a change of domicile, may trigger these clauses and potentially allow the other party to terminate or renegotiate the agreement on unfavorable terms. Worse, counterparties may refuse to recognize the new surviving entity as the contractual successor, therefore leading to enforcement problems or delays in payment. By contrast, redomestication preserves the original legal entity. There is no new company, no new contracts, no new bank accounts, no change in ownership, and no triggering of assignment or contractual termination provisions. Your legal and business relationships continue uninterrupted. Statutory merger filings may require a change of entity name, forced suffix modifications, or rejection of your current business name altogether due to availability conflicts. If the surviving entity cannot legally use the old name, you may lose a key piece of your brand and identity. Similarly, you may need to file new assumed named registrations, revise existing contracts, reprint marketing materials, and change your web presence to reflect the new entity name. If you have built years of goodwill and intellectual property around your existing company name, this disruption can be devastating and unrecoverable. Redomestication, by contrast, allows you in most cases to retain the name of the business and preserve your brand identity in the new state with minimal to no friction. A merger requires you to prepare and file documents for the new entity, merger documents in both states, documents for the old entity, IRS forms, internal records like merger agreements and board resolutions, and often requires amending operating agreements or bylaws. If you hire professionals to do this correctly, and you must, otherwise you are asking for serious headache and heartache, the legal and accounting fees can easily exceed $15,000 in many cases, and sometimes quite a bit more than that. By comparison, redomestication typically requires one set of filings in each state and can be handled for a flat fee by a qualified attorney. It is more efficient, more elegant, and frankly less expensive in every material way. Many professional licenses and state or municipal permits are non-transferable. When you create a new entity through merger, those licenses do not automatically follow. Contractors, healthcare providers, CPAs, architects, actuaries, and other regulated professions will likely be required to apply for entirely new licensure under the name of the new entity. This can lead to inspection delays, licensing gaps, and loss of revenue and credibility. On the other hand, redomestication preserves your entity's legal identity, reducing the risk of licensing interruption and thereby preserving your compliance history with regulators. Once a merger is completed, it cannot be unwound without creating serious and frankly complicated tax, legal, and administrative consequences. If something goes wrong, particularly if you try to handle it yourself, or if the merger is rejected, delayed, or poorly executed, you may find yourself operating an entity with no legal protection or separate identity whatsoever. It is possible to trigger IRS classification issues, retroactive tax filings, or even litigation among members or shareholders. There is no grace period or safe harbor for a merger gone wrong in most cases. Redomestication, on the other hand, can be paused, corrected, or clarified without invalidating the underlying business entity. Redomestication, as I've said several times now, legally transfers your business from one state to another. It is, in most cases, far superior to foreign entity registration or qualification or statutory merger, and it is certainly superior to dissolution of the original entity, which carries with it very significant legal and tax headaches and is almost always a serious mistake. Redomestication preserves your federal employer identification number, company history, contracts, credit history, licenses, ownership structure, and name in most instances because it does not create a new entity. It does not require a new formation filing when handled correctly, and it does not trigger tax recognition, IRS reclassification, or loss of legal status when handled by a competent attorney. It is a clean solution designed specifically for relocating companies between states. A merger is a workaround. Redomestication is the answer for most businesses in this scenario. In conclusion, do not let a poorly informed advisor, some random stranger on the internet, on Reddit, or ChatGPT talk you into using a statutory merger, foreign entity qualification, or dissolution to move your company. They are idiots. Merger is legally complex, tax sensitive, and operationally disruptive, as are the other options that I mentioned, although to varying degrees. These are sledgehammers where a scalpel is required. In most cases, redomestication is the right answer insofar as it is faster, safer, and far more effective. It achieves what a merger usually does not: full legal relocation of the business without disrupting its operations, finances, or identity. If your goal is to move your company, not replace it, then redomestication is the strategic, risk-managed path forward. Avoid unnecessary complexity, unnecessary legal risk, and unnecessary IRS trouble by working with a licensed attorney to redomesticate your business the right way the first time. Again, my name is Chad Cummings, and I hope that you found this information informative. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.